Hi, folks. Today we're going to take a look at Travis Hines, where he's truly gone off the deep end, and well, this one's a doozy. Not only do we have Travis trying to figure out what gives the states the rights to do what they can do, but mistakes judicial process for a TV show. But before we start today's video, as always, a big thank you to all of my current and new channel members and subscribers. Without all of your support, I couldn't keep this channel going, so I want to thank you all personally from the bottom of my heart. And if you're new to the channel, please subscribe to the page. Leave a like and a comment because it helps me with the algorithm. Don't forget to consider becoming a member, and please check out my other channel, the NCR Movie Network, where I do talks about movies, reviews, retrospectives, comparisons, and rankings. With all that being said, please enjoy today's video.
Alright, so far in my research about the 48-hour warrant, I have learned a little bit more, and I'm not so sure that they exceeded the warrant exactly in Natchitoches, Louisiana.
Okay.
It doesn't seem like Judge Ousley he seemed to have broken it up, this 48-hour warrant, where I was arrested January 22nd, 2022 at 1 p.m. and he signed a 48-hour warrant demanding that I be taken into custody immediately upon this warrant when I was just sitting in jail. So he held a probable cause hearing, and I've been going back and forth with ChatGPT on that, and it sounds like I don't have to be present for probable cause.
Now there's your first problem, Travis. You're using ChatGPT to, come up with these legal questions. And while yes, it's a good base to start to get questions and maybe to get the start for an essay, but I would rather use somebody who actually knows something about the law, like a lawyer, like the one you have. Yes, a judge does not need to have you present for a probable cause warrant signing. Now, or a probable cause hearing. Now, there are cases where you can be present. But what it sounds like is the prosecution and the police went to the judge and said, "We believe we have enough evidence to ask for a warrant for his arrest." Showing the probable cause, giving that evidence to the judge looks at it and says, yes, it's sufficient enough to sign for a warrant for your arrest. Now, if this was to go to trial, then yeah, you would more likely be asked to be there and present with your lawyer to argue the case.
Can do it based on police reports and body camera and other evidence, testimony. He could make his a 48-hour arrest warrant, and I believe I have the name of the case in my phone for the 48-hour warrant. There is a court case out of California, and they talk about it. Let's see, I got questions there. I've been doing a lot of various research. This would be
Right.
my last check. It's a habeas corpus is petitioning, initiating, and okay, no, okay, I don't. It was a case that I've never heard of before. It's 1991 out of California, and somebody versus somebody, and I just ChatGPT dug it out and keeps referring to it in a lot of my questions.
Again, Travis, this is the problems with using ChatGPT to get legal advice. Now, the case that ChatGPT is referring to, and as well as Travis, is the case of Riverside versus McLaughlin, where it was established by the Supreme Court that through a 5-4 decision that warrantless arrests in Riverside County conducted by the Riverside County Sheriffs were not sufficient enough, and established that anyone who was arrested without a warrant must be given a 48-hour probable cause hearing, meaning that they have 48 hours to take them in front of a judge to prove that they have probable cause to arrest them and hold them. Travis is trying to imply that this case might come in his favor, when in actuality it doesn't.
About how there's a 48-hour window that the Supreme Court decided is the length of time that you could spend in jail without probable cause. Now, Missouri has condensed that to 24 hours time limit for probable cause to bring you before a judge. There is a 24-hour rule, but the U.S. Supreme Court made the standard 48 hours. But yeah, in North Dakota, I sat in jail for like 3 or 4 days a number of years ago.
Oh, but baby.
2020, and there was nothing. There was no charge there, and that would have applied as well. But the judge in Natchitoches, Louisiana, my current case that's been going on since January 2022, I see that the judge immediately, within like 4 hours, wrote the warrant for my arrest. So that isn't exactly going before a judge, because I didn't know he signed that until after I was released 3 days later. So does that really count?
Yes! Yes!
I mean, he's allowed to hold probable cause without my presence. It's called ex parte. But then hold me in jail, and he only decided probable cause, that I needed to be arrested. He was aware that I was in jail. He wrote out the 48-hour warrant for my arrest, and then I saw nothing. I heard nothing for 3 days, and then I have to go into a room, and then they forget about me. I had to let them know that I'm in jail. It's been 2 days, and they just, on that second day, they said they forgot about me, and so they'd have to process me the next day in 3 days. Which, I mean, and I question, when you go past that point. I mean, even though Judge Owsley he viewed the case and he found probable cause, still there was no communication for over 3 days.
Wow, it sounds like Travis might have had his rights violated if he wasn't so full of it. You see, Travis is leaving out some crucial information. January 22nd, 2022 was a Saturday, meaning that the people that would process a warrant weren't probably in the offices to do so. So it would probably go through and be processed in on the following Monday. Not to mention, he wasn't given a 48-hour arrest warrant. He was given a warrant for his arrest within the 48 hours of him being arrested without a warrant. And yes, the judge does have the right to do a probable cause hearing without him being present, and it's not an ex parte. And something else Travis is seemingly forgetting, that every state, thanks to the 10th Amendment, have the right to establish their own laws and enforce them. So if one state wants to have a 24-hour process to process somebody in front of a judge to get probable cause for a warrant arrest without them being arrested without a warrant, and another state wants to do 48 hours, that's totally fine and legal.
Okay, and I think there needs to be some kind of communication, and I need to go back and forth with ChatGPT on that. There needs to be some kind of communication between the defendant and the judge within 48 hours, not just simply the judge signing this arrest warrant. And weekends don't even matter. Okay, 48 hours is 48 hours. It doesn't matter weekends. So judges work weekends. If somebody's arrested, the judge has to come in. I mean, in bigger cities, they have night courts. They made a whole TV series about night courts just to meet the demands for the number of arrests that occurred and meet the demands of that 48-hour warrant. It could have been that TV series Night Court was inspired, or maybe it was a TV series from the 80s. Either way, it was 91 that the 48 hours was played.
Shenanigans.
Na 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 na
Shenanigans.
na 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 na.
We're calling shenanigans, folks, because Travis is wrong about a great many things here. One, night courts are real. They're also known as evening courts. And the show Night Court that he's referring to came out in 1984. So it wouldn't have any merit to the 1991 case of Riverside versus McLaughlin. Not only that, Night Court actually hold small cases. They do small petty offenses like vandalism or solicitation or stuff like that. If it's a much more serious case that comes in front of a judge who is hosting a night court session, they'll usually hold it over for remand to where it can be processed by a judge during the following day. But, Travis, if you actually believe that the show Night Court inspired any case law, and you're going to try to use that to help your case, that is even more shenanigans we get to throw.
I don't know how long the time limit was before that. It was certainly likely much longer. But I sat in jail for that length of period of time, not hearing anything, not knowing anything. And then I get Layla Sylvester on the phone at 3 days, and she's a district judge, and she just said that I have a bail set at $1,500. And that's a district judge. That's the last I hear from the district judge. For some reason, the district judge got involved because Judge Owsley failed to get involved within 48 hours. So they just maybe put the district judge on the phone instead. Was Judge Owsley really that busy on that day or the day previously? He's a part-time city judge. And I argue that, if I'm going to have a district judge tell me what my bail is, then maybe I should have district judges, maybe I should be able to request a district judge to also hear my case and be...
That's not how it works. That's not how any of this works.
...allowed the jury trial since I was put in jail as a result of the whole matter. I should have a right to a jury trial and was denied that. So I don't understand how they can go back and forth at their own leisure. What gives them what gives the state of Louisiana the right to be able to go back and forth?
Well, that would be the 10th Amendment of our Constitution, which allows the states to make their own laws. Not to mention, probably at the time that happened, during 2022, when we were still dealing with the effects of the pandemic, they were trying to get as many people out of the jail system as they could. That's why your trial has taken so long to come around to where it is now. And yes, the district judge can issue out your bail, and you can still go back in front of, a city judge. You know why? Because of the judge pool. The pool of judges that are available to hear cases on certain days where they assign cases to people. Now, if you don't like that, Travis, well, speak to your congressman, depending on which state you're happening to be the hobo in for that week.
Judge Owsley puts out my arrest warrant. Then 3 days later, a district judge tells me I have a $1,500 bail. And then I go back to Judge Owsley again. And it's that mix and match. It's just, once again, people say that the Louisiana court system is screwy, and the people have no say in it. That's why it's so screwy, because everything is exclusive is privileged. they claim a lot of privilege for communication and information, excessive amounts of privilege for information, taking out the inputs from the defendant. So I'm just evaluating this, and it's weird how they can put out this arrest warrant but have no bail. So the arrest warrant was within hours, and then it took 3 days to hear what kind of bail I was facing.
Oh, wait, you serious? Let me laugh even harder.
I don't know why Judge Owsley couldn't figure out bail with the arrest warrant. He could just miraculously figure out, read all the information that he was given, whatever that was, police reports mainly, I guess, and then make his conclusion that yes, there's enough probable cause to go forward with the trial, but to not set any bail, and to not even hear, to have a hearing on it. He didn't bother. I didn't see him until 3 weeks later, and I was actually scheduled to talk to him to have my first hearing within like 4 months. In 4 months, they push back the date so far, almost to the point where you forget about it. It pushes back your speedy right trials, your speedy rights to the speedy trial.
But Travis, in a previous video, you said that you did file several motions that caused the delay of your trial. So they're not denying you the right to a speedy trial. And in fact, a lot of courts were overwhelmed thanks to the pandemic, causing them to have massive delays. Now, it's not like you've been in jail this entire time waiting for this trial. You've been out on your own, frauditing and being the biggest pain in the ass to all the cities and neighborhoods that you can be in.
And I asked for the next court dates. I had to actually ask. I do that every time. My court date is always scheduled far out, months, 2 or 3 months. And I'm a traveler. I want to have a faster hearing. I want to get this done sooner. I want to rock and roll with this. And so I'm always the one asking for a sooner date. Can I get the evidence sooner? Can I get a sooner hearing date? I want to get this information out because it's gotten a lot easier to write motions.
Travis is contradicting himself so much with that last statement. You want to rock and roll with this? You want to get a speedy trial? You want to get this done? Well, why don't you just go to Louisiana and be there on the 17th for your court date and get it done, instead of trying to come up with some BS motion to get it pushed back to later in the year or to the start of next year.
With ChatGPT, I mean, the new ChatGPT 01, it thinks a lot harder. So to make a request for a good motion to suppress evidence, a motion for discovery of evidence, bill of particulars, write me out a good bill of particulars. You have to input all the fine detail as specific as possible so that it can do its best work. Because I've been making some questions for the sheriff departments that I've been visiting, and
Oh my God, who the hell cares?
and I'm constantly refining them because ChatGPT isn't quite getting where ChatGPT is asking good questions, but they're a little too hard for the sheriff's department to ask. So I've had to refine them, like asking who all the tow truck companies are. Do you keep a list? And so far, out of the 2 sheriff departments that I've asked, they've said they don't keep lists. They just kind of choose the dispatch chooses the nearest tow truck company. So that's making me refine my questions, because I think I'm going to hear that more and more if I keep asking that same silly question. So I'm going to change my question to asking since it's so random that the sheriff's department seems to be calling the tow truck, because I'm facing extradition issues from another state, because I don't believe I'll make it October 17th to my hearing in Natchitoches. I'm 1,000 miles away, and I think, you know, my car might get towed if I get extradition problems. So I want to learn more about that. And one question now, after stopping at a couple of sheriff's departments I have, is does the sheriff's department, or will they, check this tow truck driver's license and insurance? Okay, I think that would be a better question to ask.
And we're going to end it here, folks, because Travis does go on to ramble more and more about if the questions he's going to ask the sheriff's departments are the tow truck driver's licensed and insured. Not if their companies are to handle his property, but if they are. Travis, I'll answer that question for you. They don't have to do that. The companies are insured and picked by random by having contracts with the city and county. So if you guys like this video, please like, share, and subscribe. Leave a thumbs up and a comment because it helps me with the algorithm. Don't forget to check out my second channel, NCR Movie Network. And with all that being said, be well, be safe, and special thanks to all members of the news team. Without your guys' continuous ongoing support, I couldn't keep this channel going, so I want to thank you all personally from the bottom of my